Hello, everybody.
All right, this is file 24-01960 SC, small claims case, Candlelight Manor Condominiums versus the Holmans. Parties are present and ready to proceed. We are here in small claims. What small claims means is that we're trying to get this done without any attorneys. In other words, nobody here is represented by an attorney. We are also asking to get this done short of anything like a jury trial, but you're asking for this just to be resolved right here now in front of me. So if the parties are ready and willing to proceed here in small claims, the first thing I'm going to do is swear you all in. You can go ahead and raise your right hands.
One moment, I lost connection. I'm here.
All right, I'm swearing you in, Ms. Behrens. Please raise your right hand. Swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
I do.
I do.
All right. Ms. Behrens, what do you do for Candlelight Manor Condominiums? I need to know that you're able to act on their behalf.
I am the president of the board of directors.
All right. I do not get too much information as to what is this in relation to. The Holmans, do you still live in Candlelight Manor Condominiums?
Yes.
All right. So I'm assuming what this is association dues being unpaid over a matter of time. Is that correct, Ms. Behrens?
It's that as well as other charges they have against them.
All right. So Holmans, this is the way it works. You are in, and they're probably not condominiums, but everybody uses a blueprint of condominium bylaws from a long time ago. But essentially, in your housing development, you have association dues, all right? So this is the way that works. You are either paying association dues or you're not paying association dues. You could have a reason why you're not paying association dues. You disagree with something about the homeowners association. But in order to do that, before we would go any further into listening to what your reasoning is, you would need to show that you have in fact been paying those dues into an escrow account. Is that the case?
Hold on, I couldn't hear you exactly.
I'll get this one.
I didn't hear you exactly all the way. Just sit down now. I didn't hear you. Can you repeat that?
Yes. In other words, you live in Candlelight Manor, correct?
Yes.
Correct.
And so Candlelight Manor has, as part of their condominium bylaws, that every homeowner pays association dues. You're here being sued by the condominium association for not paying those dues. So here is how that works. Either you are paying those dues, which it seems like you're not, otherwise we wouldn't be here, or you're not paying those dues. Now, it is possible that you are not paying those dues because you believe there's some reason you disagree with something the homeowners association is doing, and that is why you are not paying your dues. But before we would even get into that, in order for you to trigger that option, you must have been paying these dues into escrow that whole time. So one of two things is correct. Either you have been paying those dues or you've been paying them into escrow. Are either one of those two things true?
No, we missed some payments on this over the last couple of years because of financial hardness. This was not anything that we did not intend to pay.
Okay.
No.
Well, that's a little different then. In other words, on these matters, I usually am deciding because people say, oh, we don't owe, we do own it. If you're agreeing that you owe these dues and it's just more about how and when you're able to pay them, then we can do what's called a consent agreement, meaning you weren't fighting about whether or not you owed them. You agree you owe them, you just weren't in a position to pay them. If you agree with that, although I do have these past due fees and finance charges in the amount of $5,031.05. Does that sound correct to you?
Well, the past
yeah.
due, yes, but the finance charges, we would like something because we fell behind, not just on that, but when this all started, COVID hit right then in 2021. I came down with COVID. Steve was not in our house from July until December. I was here
Okay,
by the
ma'am,
kids and myself.
ma'am,
Yes.
let me explain something to you. The homeowners association could agree to charge you less in finance charges. I would not agree. I can't do that because that's part of your
Okay.
contract with your homeowners association. And so, Ms. Behrens, I don't know if as president you have any room. In other words, it seems to me they are not here contesting that they owe money. They're ready to enter into a consent judgment that there is an amount of money they owed. They just need to work out the how and when they're going to pay it. What they're asking for, I guess, is if there's any wiggle room with the homeowners association to forgive finance charges and just go with association dues for times they missed. That's completely up to you as plaintiff.
Basically, we treat everybody the same, so we don't feel that we should do that. It's not that much. And the last time I talked to Kayla, she said we were planning on doing payments, and I said, how was I supposed to know that? And I said, would you write it up, sign it, put it in our box? But I've heard nothing, and I get no
Penny, that was after 2 days after you called me, after I got served these papers on
Okay,
the
Ms.
20.
Holman, but here's the point though. You guys always have the options to make agreements short of coming into small claims. But once that affidavit is filed, they have a right to recover monies that are owed to them. These monies are contractually owed to the homeowner. So
We're not disputing that we don't owe this, but when I signed for these papers on the 26th, she called and then we had a conversation on the phone on the 28th. And she demanded her money because they have a building that they need to pay for. And I did tell her that we want to pay for this and set up payment arrangements. But then she told me to put a letter in the box and she will see what they think that they want to do with it.
That's true.
okay, but what I mean is all of that matters before we get to this moment. Once we get to this moment, that becomes irrelevant. All the maybe agreements you guys had. Essentially what you have here is a past due bill that is spelled out in your homeowners association for what, not only whatever you owe for a month, every month that you got behind, but what the finance charges are. I find the finance charges here to be very reasonable given the amount of time that you haven't been paying dues. So the only other thing I would need to explain to you is this. The homeowners association also paid certain monies out of pocket to get here today. They had to pay a filing fee and they had to pay to have you served. That cost them $94. They're also able to recover that as what we call costs as opposed to the damages. The damages is the amount $5,031.05. But essentially what I would do is write this up as a consent agreement, meaning the parties are in agreement that there is money owed. The court does not handle collections. So essentially what's going to happen is you're both going to get a copy of this order. The only way to satisfy this judgment, Holmans, is to satisfy the judgment to the either pay the judgment out in its entirety or whatever agreement you come up with the homeowners association that satisfies the judgment. But essentially we're all set for what we need to do here today because we're not actually fighting about anything.
Well, we need some kind of payment arrangements because there's no way that we can pay the 5,000 right up front. That's what we were trying to tell. So I was trying to explain to Penny too. Like we are trying to get caught up from 2020.
But what I'm telling you is the court does not involve itself in what your payment arrangements would be. The court has to decide, is there a dollar amount owed to the plaintiff and what that is, and it's either by contested hearing or by consent. So we're all on the same page as far as what my role is. Now what happens is you'll both get a copy of that consent judgment. You need to be in contact with each other and work out the how and when that's going to get paid.
Okay, because part of the problem that we had before, as my wife and I were talking about, you know, how we were going to do this or make payments and so forth, there really wasn't any phone numbers or anything posted anywhere to get a hold of people that are on the board.
You have my number. You have
No,
it.
I did not. No, I did
Well,
not. And
that's as simple as this. You guys are now taking up court
personally.
time with your business. Miss Behrens, would you like to put a phone number on record so that they can contact you?
Well, no, I have stuff now. Like I went down and took pictures.
All right.
It doesn't matter. That's irrelevant now. That doesn't matter. But this was a waste of time anyway. I wanted to set up payment arrangements with them in the first place, but it just has been I can't.
Well, I'm going to go ahead and release parties. You'll get a judgment in the mail. What's that, ma'am?
Do I go through Penny to set up payment arrangements then?
I don't know, ma'am. I'm going to release parties. Thank you. Ms. Behrens, who would they contact as far as the board members to make arrangements for payments?
Right now, they contact me. And the way
Alright.
we do it is you write it up, what you would like to do, sign it, put it in our one box that we have. We will take it, we will talk together as a board, and we will get back to them. I'm not saying we're going to agree to it because we're really tired of the promises.
All right, I'm going to release parties. Thank you. This is a citation. This was issued on September 9th of this year on US 131 there in Gunplain Township. This is failure to yield to emergency vehicle. Ms. Morehouse, you're here on this citation to do one of three things. First is you could admit responsibility to the citation, or two, you could admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened. Or three, you wish to contest this citation, in other words, fight the ticket at what we call informal hearing. What were you looking to do?
I was looking to fight the ticket.
No.
All right, then the first thing,
Go ahead.
if you wish to contest the ticket, the first thing I'm going to do then is swear you both in. So if you could raise your right hand, same as the trooper, your other right hand. You swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
I do.
All right. Ms. Morehouse, makes a lot more sense for me to start with the trooper. He has the burden to establish to me why you were issued a citation in the first place. But after that, you'll have an opportunity to either ask questions or testify on your own behalf. All right. And with that, trooper, you want to start the narrative somewhere where it makes sense? Explain the issuing of this citation.
Yes, sir. So on the day that this happened, I was finishing up another traffic stop on 131 near the Plainwell exit. The vehicle that I had stopped had just carried on down the roadway as I had just issued them their citation. I was back in my vehicle updating my computer. There was pretty minimal traffic at that point in time, and that is when Mrs. Morehouse passed my location in the lane closest to me, despite having the ability to move over to the furthest lane available. It was at that time that I caught back up to Miss Morehouse, activated my emergency lights, spoke to her about why I stopped her, and then issued her a citation for failing to yield to emergency vehicle.
All right. And Ms. Morehouse, what is it you'd like to tell me?
I would like to tell you that I was not aware of the rule of slowing down. And I would like to tell you that I believed that I could not make it to the left side due to a car next to me coming up quite fast. And I didn't believe that I could make it over to the left side. I was not aware of the rule to slow down. Mr. Casey had told me that there were billboards in multiple places. I have never seen those billboards. And I'm mostly from the Plainwell area, so I'm not sure if that would be a reason to why I've never seen them, if they are not in the Plainwell area.
Okay, ma'am, this law changed like, I don't know, 5 years ago. So probably before you even had a driver's license. So the billboards, I mean, that was part of the campaign to get everybody up to snuff a long time ago. But essentially, here's your problem if you ever heard this phrase: ignorance of the law is no defense. So in other words, if you're driving in the laws of Michigan, you're supposed to be aware of all the laws in the state of Michigan. And the move over laws sort of clearly there. It's not, we used to give breaks many years ago for people just sort of when this law first came out, but it's been firmly in place for quite a while, quite literally, because before the law was changed, the last 5 state troopers that had died in the line of duty were not shot by bad guys. They were all hit by cars. That's why they sort of changed this law. But 2 things, just to be clear for you in the future. One is you do need to move over. And sometimes you can't move over because there's cars in that left lane and you can't move over. So if you can't move over, then what you have to do is drastically slow down what your speed is. You have to do one of those 2 things. The testimony here from the trooper is, first of all, that you could have moved over, even though you disagree with that. But second of all, that, there didn't seem to be much of an attempt to slow down. I think even by your own admission, you didn't quite know that was an option for you. But the problem here is you not knowing that you're supposed to do this is not a legal defense to the ticket. I have to decide, according to the statute, did you do this or not do this? I would find, after listening to the evidence, that you did fail to yield to that emergency vehicle by either moving over or slowing down a lot. I'm pretty sure they probably have to cover that during driver's training. I looked at your birthday, you seem kind of young, that's probably something they went over. But in the future, make sure you do that because it's a real expensive ticket. It costs way more than all the other tickets, but that's why that's the incentive for you to do it. Now, because you had a contested hearing, you do have a right to say, hey, I don't agree with what just happened there. I want to go in front of the district court judges with the prosecutor's office for what we call formal hearing. And you have a right to do that if you disagree with my ruling here today. But to do that, you must do 2 things. One is you must ask for that formal hearing within 7 days of today's date. Your window of opportunity to contest this further closes after 1 week. And secondly, you must come in and post a cash bond in the same amount as the fine to guarantee your appearance at formal hearing. But do you understand your rights on appeal?
Yes, I do, sir.
All right, then we're all set for what we need to do here today. I'm going to go ahead and release parties. Thank you.
Thank you, sir.
Be safe, be well, sleep sweet, and much love.